Ashmore coming to you from the studio. We're talking about family violence protective orders and what a private citizen can do. In that last video bit, I talked about what the state prosecuting attorney can do, and that kind of falls into its own little magical, what have you, its own little deal. And a private citizen doesn't have the right to that relief because only the state prosecutor can seek that relief from the district court. So that's not something a private attorney can help with. And those are usually very serious cases where the state prosecuting attorney's office is getting involved to take that emergency protective order, turning it into a more expansive protective order. And if there is some signal that you're getting that is an escalation in the merits, certainly in the eyes of the state of Texas regarding the issue of family violence, it is, right? When it goes from an emergency protective order to a protective order sought by a district attorney in your county, then that means signal should be up. That is being taken very seriously, those allegations. So the other things that can occur, now this is private citizen or state seeking a protective order. Either way, you can ask the court for a hearing without the other parties being notified. You can ask for and be granted an emergency ex parte, which is Latin meaning without the other side, hearing for the immediate protection of the victims of family violence and abuse. And that's a timeout, 14-day window. The hearing's going to come super quick. And it can feel to the recipient of an ex parte order like, wow, I just got my feet swept away and now I've been excluded from the home and it may seem unfair. However, those allegations have to be specifically set out, that it's brought by members of the household, it's brought to protect members of the household from family violence and abuse. And that abuse, like I said, has very, very broad definitions. And the fact of the matter is those broad definitions are there to protect the victims of family violence who are all too often caught up in what we call the cycle of violence. It's abuse, cry for help, reconciliation. Abuse, cry for help, reconciliation. These are things like the Women in Need charity that I mentioned in the prior video bit. That's what their job is to do, to help the victims of violence find a way to get out from under that. And that's very difficult. And we know it's difficult, but it's one of the reasons why the first shot in front of the court is without the other side, right? To prevent further violence and to protect those who need it the most. Then there's 14-day window. It can be extended, but typically within 14 days, there's going to be a hearing as to whether the protective order should or a restraining order should go forward, and what's that going to look like, and now, let me back that up just a second. There's an opportunity there for the person who's the subject of the protection, in other words, the alleged abuser, the alleged other spouse who is doing the bad acts. They can make a deal there to prevent a hearing on family violence and abuse. They can do some things in that 14 days that could be to their benefit. And sometimes you're in a position where you cannot do that. But that's an opportunity to compromise and negotiate, and if possible, protect yourself and avoid a final finding of family violence, which a temporary orders hearing may not necessarily be a final finding of family violence in the eyes of the Texas State Court, but what's that going to mean for your ChL rights? What's that going to mean at the federal level? These are things that are changing all the time. You just need to be cognizant of it. You need to be cognizant. If Second Amendment rights are important to you, you want to go hunting with your kids and your grandkids one day, maybe this is a hearing you want to avoid, you want to negotiate on. But in that 14-day period, there's really not a lot you can't ask the other side questions, right? So it's one of the few times where it can be like a surprise attack. You have notice of the hearing, but you don't know what witnesses, you don't have the right to get that from each other like you would in a final trial. right? Where there's an opportunity to exchange written information, there's an opportunity to exchange witness and exhibit lists, and so you know what's coming at you. At these temporary orders hearings, temporary protective order hearings, temporary restraining order hearings, you don't know what's coming at you. It can be surprise witnesses. You have your witnesses, they have theirs. You have 20 minutes to tell your story, and the judge gets to hear it and make the judgment call, not a jury. It's a judge trial only. Because the legislature says we got to make these decisions, we got to make them fast, we got to make them to protect children. There's a mandate from our legislature to do that, and that's why this is such an accelerated process. So it's a lot of scary things and a lot of moving parts, but again, more on that next. But don't let it overwhelm you. Be a little bit nearsighted. Look at the steps right in front of you. You need to think about the next set of downs, right? Get a first down, then get another one. You don't need to figure out how to win the Super Bowl. Don't need to figure out how to win the entire hearing. Need to complete this set of downs, get another first down. All right, more to come on protective orders in our next segment. Thanks so much. Please like, subscribe, and share. More in the studio next.